very clear that the tone that we get when we make an objection that should be sustained is, what are you doing? That's what was said. You specifically...
Lower your voice and don't yell at me. I told you before. I'll listen to what you say. Speak in a normal tone of voice.
Judge, we're doing the best we can to make sure that this trial is ethically conducted. They have repeated, I've objected, you told them it's improper. You've overruled repeated objections where they are saying improper things. He just said a moment ago, this is a direct quote, the prosecution accepts their witness committing perjury. I object. You respond, that's appropriate comment on the evidence. It is not appropriate comment on the evidence, Your Honor. I don't know if you didn't hear it.
I didn't hear that.
So, Judge,
What I heard, I could have been wrong, what I heard was that Mr. Tacopina was describing Relly as committing perjury.
Judge, that's a direct quote. The direct quote was, the prosecution accepts their witness committing perjury. Here's another one. Relly committed extortion. There is no legal...
Do you think the jury's going to ask for what the legal description of extortion is?
Your Honor.
Forcing someone to pay money, that is, quote, extortion.
No, Your Honor.
Go on to something else.
Your Honor, I want to make my record. I mean, you're going to do what you're going to do, but I have a right to make my record. No lawyer can get up here, no lawyer can get up here and tell the jury that a crime has been committed when there is no instruction on that crime. When in fact, Your Honor, that's not the legal definition of extortion. We've objected, and the court again is basically telling me, don't worry about it, it doesn't matter. Your Honor, it does matter. After a while, when there are so many of these things, they add up. And when the court is saying, wow, what they don't care about it.
No, I didn't say they don't care about it.
It seems, Your Honor, it's improper argument. And the problem is
I don't agree with you. I think using the word, quote, extortion to describe the conduct is not improper. I think it's fair comment on the evidence. You, in your rebuttal argument, you can say it wasn't extortion. You can address it.
Your Honor, the bigger issue, as I said, is the court repeatedly told them, do not connect the prosecution to committing crime.
I'll tell you what, I didn't hear that. I'm going to ask Kathy for the exact quote. If that's what was said, I'm going to sustain your objection, and I will apologize for overruling.
You told counsel before we started, do not disparage the other side. I said yesterday, you argue what you want about witnesses. You say a witness lied. You do not disparage counsel. You repeated it yesterday. He tried to explain how he didn't make mistakes yesterday, which he did. Now he gets up and he's now admitted, yes, I made that comment, here's why it's appropriate. Your Honor, it's not appropriate. It's completely unethical. It is immoral, and it's not professional. And again, Your Honor, the fact that he is getting up here saying, well, yeah, I said it, here's why, just demonstrates again, he doesn't know the law or doesn't care.
You're disparaging him right now.
I'm disparaging him because, Your Honor, he's not following the
There is not to be any disparaging of either side.
During argument, the jury's not here. I have every right, obligation, and duty to stand up here and point out when he is being unethical. The first time the court catches me being unethical, Your Honor, the court knows. That'll be the first time. The court knows. I don't do that.
Oh,
court knows. Court's already made those.
I've heard enough from both of you.
I just want to put on the record that his remarks about being unethical, I just about had it with him. This from a lawyer who, and I used the same essay on it. This from a lawyer who asked in front of a jury for a stipulation that a shooting range was not in California when either he knew it was in California or had no idea that it was in California. Okay, so he literally asked for a stipulation in front of a jury that he knew was not true or didn't know if it was true, and that's unethical. That's unethical. And this is a guy who, the Ninth Circuit, just said lie to a jury in the Brantford case.
Your Honor,
so
Your
I
Honor,
want to hear about him.
one more thing out of him, and we air everything that's happened in this case, which the court's aware of.
Stop.
He might want to stop.
I'm so threatened.
You should be, Joe.
Oh, yeah.
Let's take a break.
You should be.
Don't tell the courts ever told me I was a liar.
Hold on, hold on. Hey!
Oh, yeah. I'm so scared of you.
Stop it!